Good morning and welcome to the latest in the series of Flexible Space Association Workspace Wisdom webinars. I'm Jane Sartin, the Executive Director of FlexSA, and we're looking today at changes in employment laws, which I think are going to be really relevant to our membership running flexible workspaces and related businesses. And we're joined by Lauren Harkin from RWK Goodman, who are a service provider member of the Flexible Space Association. And in a moment, I'm going to hand over to Lauren, who's going to take us through a presentation. If you've got any questions, please do put those in the chat box, but we will take them all at the end of Lauren's presentation, and there will be an opportunity then if you think there's anything that maybe you would like a bit of clarification on to add the question at that point as well. So, Lauren, I shall get your presentation up. There you go, and leave you to present.
Thank you, Jane. Good morning and welcome to everybody, and thank you for joining us. I'm going to do a quick overview of the reforms that we've had on employment law, but in particular, I'm going to focus in on the sexual harassment reforms that we had at the end of last year. So I'm hoping there's going to be a little bit of something in here for everybody, because there's some interesting implications, particularly relating to the sexual harassment reforms, which mean that actually the obligations now on businesses to protect their employees from sexual harassment isn't just an obligation to protect employees from sexual harassment by other employees, but it's an obligation to protect those employees by all sexual harassment, which includes sexual harassment by third parties. So as you can imagine, in flexible sort of working spaces where you have sort of perhaps a number of businesses in there together, there are going to be some implications. So a quick overview to start with in terms of the sort of main changes that we saw on the employment law front last year. So first and foremost, we've been talking about it for a number of years, flexible working. Finally, last year in April, the government implemented some changes which basically made the right to request flexible working a day one right. So there's no requirement on businesses to grant flexible working. You go through a process, and there's certain criteria that you consider as to whether it's viable for you. But it is now a day one right for employees to be able to request flexible working. They don't have to set out the impact that their request will have on the business. You do have to consult. So with employees that make those requests, employees can also make 2 requests in any year. And the requests have to be dealt with now in a 2-month period. So that's flexible working. We also saw some changes last year relating to people that were on family leave in a redundancy situation. So the previous situation was that for employees that were on maternity leave or adoption leave or shared parental leave who were at risk of redundancy, they had first refusal insofar as there was a suitable alternative vacancy available. So those people that were on that type of leave, they trumped all others. They didn't need to be the best candidate. If they were away from the workplace on that family leave, they were entitled to be offered a suitable alternative. It did, however, only relate to the period of time that the employee was away from the office. So they were away, they were on the leave. What happened last year from April is that the government extended that period. So now it doesn't just cover the period of time when the employee is away from their place of work, they're on leave. It also covers, in the case of pregnant mums, it covers the period of their pregnancy. So if they're pregnant and they're notified at risk of redundancy, they have that right of first refusal to suitable alternative roles. The whole of their maternity or adoption leave or shared parental leave, but for a period of 18 months. So for somebody that takes 12 months maternity or some other form of family leave, they can also add 6 months when they come back to the office. So the protection is now in place in terms of protection from redundancy for a much greater period of time for employees that are on family leave or are about to take it in the case of pregnant mums or have recently returned. We also saw some changes to paternity leave last year. Previous position was that employees could take 1 or 2 consecutive weeks, but they had to take it in the first 8 weeks of the baby being born. Last year, the government said, let's make this more flexible. And now paternity leave, so this is for dads or partners of mum that have had baby. Basically, they can take either 1 or 2 week blocks, doesn't have to be consecutive, and you've got a whole year to take that leave. So if there's a more appropriate time for people to take the leave, they can do so. Carers leave was introduced last year, so it's something that's been spoken about again for quite some time. So from April last year, employees can now take up to a week's unpaid carers leave in any 12-month period. So this is a different type of leave to sort of time off for dependents or an emergency type of leave. This is where an employee has a dependent who is a spouse, a civil partner, a child, or a parent. A person who lives in the same household as them or reasonably relies on them. So providing they can establish that they do have that long-term care need, if the employee needs to take off time to support them with their longer term care arrangements, not emergencies, they can now take up to 1 week in any 12-month period. It's unpaid, but it can be split up. It can be split up into half days, full days, however it needs to be taken. So it's quite a useful tool for people that are juggling work with caring requirements at home. So they were the main changes for 2024, up until October, that is, when they introduced some reforms on sexual harassment. Now, I've put on the slide some images about the recent cases on sexual harassment that we've seen. So, in its absolute worst format, you have sexual assault. And we saw last year the ex-Harrods boss, Mohammed Al-Fayed, in the news with a number of claims by female employees of sexual harassment, including assault. We saw Greg Wallace in December, various complaints of his inappropriate behaviour that was of a sexual nature. We've seen McDonald's in the press, and we've repeatedly seen Strictly Come Dancing, which started out with the fallout between Amanda Abington and the pro dancer Giovanni Panici. But even as recent as yesterday, you'll have seen the singer Wyn Evans having to take a step back from his current tour commitments due to inappropriate behaviour, again, which constituted sexual harassment. We've also seen some unusual tribunal judgments. So you'll see on the screen there, air kissing a colleague was not seen to be sexual harassment in a tribunal towards the end of last year. But context is always everything with these types of claims. And whilst in this specific case, they found that air kissing didn't constitute sexual harassment, there are absolutely other circumstances in which it could do. So, what I'm going to cover about particularly sexual harassment is I'm going to do a quick overview on the types of discrimination that we have in employment. I'm going to run through quickly. I won't bore you with the sort of legal jargon, but I'll run through what the protected characteristics are under the Equality Act. So these are the characteristics that people have to be safeguarded from discrimination. I'm going to talk about what harassment is more generally, focus in on sexual harassment, a little bit on liability and consequences, the new statutory duty, what you can do, and a couple of case studies at the end. So let's jump on to the next slide. So first and foremost, just to give you an overview of the protections that we have in place against discrimination. So they're set out under the Equality Act, which encompasses all forms of discrimination. And I'll come to those various characteristics in a moment. So the first form of discrimination you have is the most straightforward. It is direct discrimination. So basically, an employer doesn't offer a job role to somebody because they are pregnant, or they pass somebody over for promotion because of their race or their sex or their sexual orientation, something like that. It is direct. It is because of the characteristic that they have. We also have slightly more tricky indirect discrimination. So this is where businesses, they have, we call it in law a provision, a criteria, or a practice, but it's easier just to say they have a policy or they have a practice that indirectly affects particular groups of people that have a certain characteristic. So restrictions on, for example, part-time working will still indirectly discriminate against women who still bear the brunt of the childcare requirements in the UK. It's those sorts of examples that give rise. So it's, on the face of it, the policy is not discriminatory, but indirectly it will impact particular groups of people. Just for background, I've popped up on the screen today, reasonable adjustments and discrimination arising in consequence of this will be a disability. So 3 and 4 on your screen are limited to disability discrimination, so making reasonable adjustments or discrimination to people that have disabilities because of something that arises in consequence of their disability. Harassment, which is the focus for today, so we're going to look at that in a lot more detail. And of course, victimisation. You do have to be careful in your businesses if individuals complain about some form of discrimination and are then later victimised for making that complaint, like they are passed over for promotion or their salary increases is impacted. So that's the different types of discrimination. You have to have a protected characteristic to be discriminated against in the course of your employment. Now, on the screen are the 7 protected characteristics that are covered by the law on harassment in the UK. There are 2 more. So there's pregnancy and there is marriage and civil partnership, which are protected characteristics from discrimination, but they're not covered by the law on harassment. So just the ones that you see on the screen, you can't harass people because of their age, their disability, their sexual orientation, their religion, their race, gender reassignment, and sex, which includes sexual harassment. So you might be asking, well, what's this all about? What is harassment? So harassment is basically, in its simplest format, it is any unwanted conduct. So the unwanted conduct has to relate to a protected characteristic. So if we go back to the previous screen, it has to relate to their sex, their disability, their age, so on and so forth. And it has to have the purpose or effect of violating dignity or creating or an intimidating, hostile, degrading, humiliating, or otherwise offensive environment. It's interesting. The next slide, I'm going to talk about purpose or effect. When it comes to harassment, purpose is rarely relevant. So generally, people don't deliberately set out to upset others. They don't set out to sort of violate their colleagues' dignity. They don't plan to upset them or cause offence. So purpose is sort of rarely seen in cases about harassment. So the focus is basically, does the unwanted conduct have the effect of creating that sort of circumstance where they feel violated, they're upset, anything that is otherwise offensive to them. So it's the effect of their conduct that we tend to concentrate on. And when you take that into account, what you have to bear in mind is it is the victim's perspective. So I find myself saying to clients, unfortunately, in harassment in particular, and in any kind of discrimination type scenario, you very much take your victim as you find them. And what might be acceptable, what might even be absolutely hilariously funny to one person, actually is offensive to another. So it's very much down to the victim's perspective. Any other circumstances in the case that are relevant, and of course whether it's reasonable for the conduct to have that effect. So people can't just claim harassment on something that on the face of it obviously isn't offensive. You know, if they're being sort of overly sensitive, there is some protections in law in there. So I explained at the start that we were going to focus on sexual harassment this morning, and the fact that we had some reforms relating to sexual harassment last year. So why are we doing this? Why are we focusing, and why is the government focusing on reforming the laws relating to sexual harassment? And it's simply, you go back to my earlier slide. It's really prevalent. Back in 2023, the Trade Union Congress did a survey. We had as many as 3 in 5 women saying that they had at some point in their careers been subject to sexual harassment. So that's why the focus was on sexual harassment and why they made the changes that they did last year. So the Equality Act itself prohibits 2 types of sexual harassment. So conduct of a sexual nature or less favourable treatment because the employee rejects or submits to harassment. So very much today my focus is going to be on the initial conduct, the conduct of a sexual nature, but obviously just bear in mind that there can be less favourable treatment because harassment later down the line. So in the example of perhaps where a manager wrongly believes that there might be some sort of relationship intent with one of their employees, and that employee rejects the manager's advances, if later down the line the employee is passed over for promotion because they rejected the advance, then that itself on its own will be separate, less favourable treatment. So that's what sexual harassment is. I've popped some examples up on the screen for you to read, but just by way of hopefully some useful background, in my experience, I would say that sexual harassment tends to arise in 3 sort of main scenarios. So the first is jokes and comments. So you'll see on the screen there sexual comments or jokes, gestures, images, that sort of stuff. So jokes or comments that get out of control. So it might be funny to start with, and then it goes into language that's just not acceptable. A little bit like if you saw it in the news yesterday, the comments made by Wyn Evans. So your first scenario tends to be jokes and comments. The second is socials. So any kind of social event, normally where there's alcohol involved, people are sort of not that aware of the normal workplace boundaries. So the guard is let down, alcohol is flowing, things happen. And the other one is working relationships and sometimes even friendships that develop at work. We all know how long we spend at work, so it is understandable how these relationships develop. But the other form of sexual harassment relates to where one party misinterprets the feelings or the intention of the other. So that's where you tend to find it. Jokes and comments that go out of control, social events, and then workplace relationships where perhaps one party has misinterpreted the intentions of the other. So liability for sexual harassment is uncapped in terms of compensation. So there's no limit if an individual goes off to an employment tribunal with a claim. There is actually no limit in terms of what compensation can be awarded to the victims of sexual harassment. It's a liability that can be apportioned to both an individual perpetrator of harassment as well as the employer business. So there can be vicarious liabilities, what we call it, for employers, so for the business, as well as individual perpetrator liability. And of course, there's reputational damage for the business as well as the perpetrator. And the reason I say that is because if a sexual harassment claim goes to an employment tribunal, that employment tribunal judgment and indeed the hearing is public. There's no limitations in terms of who can go and see that hearing, who can view the judgment that's later released online. It can cause reputational damage, and I've seen it firsthand. So we dealt with a case for a business last year. It went to a tribunal. We successfully defended that claim for the business, and the Daily Mail got their hands on it and it was reported in the press. And even though we had been successful in terms of defending that claim for the business, of course, all the individual the supposed perpetrators or harassers were named. And when you go to a tribunal, even if you manage to successfully defend the claim, if that's what you're doing, you get an absolute hammering, to be honest with you, in your cross-examination. So, you're not going to come away from it unscathed, is the point here with liability, and really why, we need to avoid sexual harassment claims at all cost. I mentioned that compensation was uncapped, and the first element of a compensation claim is what we call injury to feelings. And we deal with what we call as lawyers vento bans to determine injury to feelings. And just to give you a bit of a feel for what just an injury to feelings alone award can look like, you've got the lower bands, which tends to be sort of one-off incidents or more minor incidents of sexual harassment, with a band of compensation between £1,200 and just under £12,000. You've got a middle band that's just under 12,000 that goes all the way up to 35,000, which captures most incidents of sexual harassment. Sometimes those that involve the loss of a job as well. And then the upper band starts at 35,000, goes all the way up to over £58,000 for your most serious cases of harassment. So either where perhaps there's been unwanted touching or an assault, or where the harassment has taken place over a number of years. So victims of harassment can claim that injury to feelings element. They can also claim personal injury where the situation warrants it, but then the biggest part of an award can be future losses. And in the worst of situations, there are examples where you have people that can't work again because of the treatment that they have suffered. So that's the sort of liability aspect. We've worked for a number of years with something that's called an all reasonable steps defence. So as a business, if your employer can demonstrate that they took all reasonable steps to prevent sexual harassment, this operates as a complete defence for the business, so for the employer, to any claims. And the claims then just proceed against the perpetrator. It's probably quite important for me to say at this point, the value of the claim is simply the value of the claim. And tribunals don't take into account the sort of the money or the resources that are available to an individual perpetrator. If somebody has a degree of injured feelings and they suffered a degree of losses, that will be the award, and they won't take the resources available to a perpetrator or to a respondent into consideration. And the point about the all reasonable steps defence is, in order to successfully rely on it, the business has to demonstrate that they have taken all reasonable steps and not just some. So it tends to be the case that your business can't rely on sexual harassment training that's 2 years out of date. You have to do everything. You have to update your policy. You need to make sure that sort of a zero tolerance to sexual harassment is lived and breathed in your organisation, that you keep refreshing and updating your sexual harassment training, all these different sorts of things. So we've had the defence around for a number of years. But also, more importantly than just being able to rely on defending claims, there are the consequences of having sexual harassment in your workplace. So people that are victims of sexual harassment tend to have greater levels of sickness absence, reduced productivity if they're continuing to come into work. You have grievances issued, which obviously are serious, they have to be dealt with, but equally they're a distraction to the bigger picture, the work that you want to be getting on with. And also you have the issue of having to deal with disciplinary action for perpetrators of sexual harassment, which might include dismissal for your most serious incidences of sexual harassment in the workplace. So moving on, I said at the start that we had a new statutory duty, and that's what happened at the end of October last year. The government brought in this Worker Protection Amendment of Equality Act, which basically inserts a new provision, Section 40A, into the Equality Act. It's no longer optional So the defence, the reasonable steps defence, has been turned into a proactive duty. So it's basically, you have to do this now as a business. It's a legal requirement. It's not just limited to preventing sexual harassment of employees by employees, but there is also a duty in there to prevent sexual harassment by third parties. So in the context of shared working space, there is that risk there that businesses have to protect their employees and prevent their employees from being the subject of sexual harassment by other people that are in that workspace. So that could include other businesses, it could include visitors, contractors, suppliers. It's a huge list. So it's a really significant sort of issue for businesses that needs to be given proper consideration. You need to look at your policies, your procedures, your terms of business, your communications to make sure that it is very clear that there is a zero tolerance to sort of any unacceptable behaviours, and in particular to sexual harassment. So people often ask us, well, what does this all mean? We have to take reasonable steps to prevent sexual harassment in the workplace. So you have to implement your policies. You need to review those policies regularly, make staff aware of their obligations as well as the implications. Train people. Train your staff. So all employees need a certain level, sort of an educational awareness level of sexual harassment, what it is, the fact that there's a zero tolerance to it, as well as your managers and supervisors who need additional training on dealing with any issues that arise. Get your surveys out and act on any initiatives that are proposed by employees. So, ask employees, have they seen it in your workplace? Get your risk assessments done. What do they suggest the business could do to prevent harassment taking place? And then finally, just deal with complaints sort of swiftly and effectively in the event that you do get some. So on to the next slide. What can you do? So in your businesses, obviously, if you're aware of harassment taking place, speak to your managers, speak to your HR teams, report any incidences using internal procedures, which may, of course, include the third parties that I mentioned. In the businesses that are in the flexible working space, and then just ensure that there's a clear messaging in your workspaces about acceptable behaviours and zero tolerance, and also that the businesses you're dealing with in those locations are communicating that message to their teams and to their staff. So we can go through a few case studies, just remembering sort of context is everything. But before we jump onto the case studies, I just wanted to mention the sort of the third parties point. And this is an interesting point because although in terms of the proactive duty, so the positive duty that's now on businesses to ensure that they're taking reasonable steps to prevent harassment, although the guidance that's set by the Equality and Human Rights Commission says this is a duty to prevent harassment, of all employees by whoever they come into contact with, which is this point that raises about third parties. At the moment in law, there are very limited circumstances in which an employee of one business could actually pursue a claim against a third party. So that bit hasn't been properly addressed, but the proactive duty is still there. Businesses can have visits from the Equality and Human Rights Commission now. So a little bit in the same way as your business can have a visit from HMRC, or they can have a visit from the Home Office where they're a sponsored licence holder. You can also now have a visit from the Equality and Human Rights Commission to make sure you're complying with your positive duty to take those reasonable steps to prevent harassment. So in the same way, we've got that third party issue. It's difficult to see how that's going to be policed. The employee could still have claims against their employer, But the actual claim against the third party is going to be a bit more tricky. You still have to comply and still take steps to try and prevent that. But we have a new government, and they are planning some reforms next year in the form of what's called an employment rights bill. And one of the topics on their list for that is to include something there to deal with this loophole where there's no standalone case against the third party perpetrator of sexual harassment. So moving on to some case studies, and I mentioned at the outset that reforms have taken place on sexual harassment because it is so prevalent. We are seeing it. I'm seeing it in my day-to-day job. In the last year, we've seen several cases of sexual harassment. We've seen 2 really serious sexual assault cases, as well as cases that are driven by comments, that are driven by what I mentioned earlier, relationships where one party misinterprets another party's intention. So just be aware, obviously, context is everything. Comments like "you look great" on the face of it may seem absolutely fine. But if that comment, "you look great," is then backed up with some messages that make an individual feel uncomfortable about comments on their appearance, they are capable of being sexual harassment. Giving people hugs in the office, any kind of touching, again, it's a danger area, and I would always recommend, in circumstances where it may be appropriate to give people a hug because of circumstances, that employees should be advised. You really need to ask that person, can I give you a hug, before the person just goes in. Asking people if they fancy a drink after work. If that invite is to a group of people, on the face of it, it wouldn't very obviously be sexual harassment. If it's just to one person, perhaps in circumstances where there's a power imbalance, so you've got a more senior manager asking a more junior member of staff, and perhaps it's backed up with other comments or flirtatious messages, then you can see how those types of situations evolve into sexual harassment. So that's a bit of an overview on some of the case studies that we're seeing, and how things can evolve into a scenario of sexual harassment. As we just wrap things up for the morning and just take any questions, I just wanted to make the point that in this sort of in the workplaces that we're all working in today, we are more diverse than what we've ever been. We also have different generations, which we've always had in workplaces, but the tolerances now of those generations is very different. And we have to keep making the point time and time again that as we sort of move forward as a society, or as different generations sort of come through and into the workplace, what one person might tolerate as not being offensive, another person won't. So it's just sort of being aware that people do have different tolerances. It doesn't have to be directed at a certain person. So if a joke is made, simply because one person has heard that joke, even if it's not directed at them, they can still find that offensive, and it can still meet the definition of sexual harassment. So just be aware of that. Be aware of the fact that something that you might have said 2 years ago, or 5 years ago, or 10 years ago, perhaps just isn't acceptable by today's standards. So on that note, I am going to wrap up. I can pass back to Jane. Jane, I'm happy to take any questions that anybody has. When we circulate the slides after this presentation today, I will make sure that my email address is circulated to anyone that might want to pick up on any questions that they don't want to do in a live fashion, and wish everybody a good day. But please do put forward those questions if you have them.
Thank you very much, Lauren. There was a lot of information packed in there. So we'll just give a moment for anyone to add any questions. And as you identified, the third-party aspect here is particularly relevant to the flexible workspace industry, because there might be relatively few employees of a workspace operator within a serviced office setting, but there will be lots of other people. And you were saying that at the moment it's not possible to claim against another business. Could an employee claim against their employer if they didn't feel they'd taken enough steps to protect them from sexual harassment?
So there's certain claims that they could bring against the employer. And one main claim might be constructive unfair dismissal. If they haven't, if their employer hasn't maintained a safe working environment for them. So there are still claims that could exist that they would have against the employer, albeit if they can demonstrate that they took the reasonable steps to prevent the harassment, the claim against them for harassment won't be able to proceed. So there's certain claims, but it's very much a case of sort of watch this space at the moment to see what they bring in with the proposed reforms over the next few years.
Yes, and the new government has obviously said quite a bit about that they will be bringing further employment law changes in. Is there any timescale to those at the moment?
So at the moment, all they've indicated to us is that they're not likely to implement the changes before the autumn in 2026. So it seems we have a bit of time on our hands, but it's not to say they won't bring it forward. So it's not set in stone that it will be, but at the moment they're saying they don't anticipate that the changes will come in ahead of autumn 2026.
Yeah. And will they be covering a much broader range of topics than you've covered today?
They will. So obviously the focus of today, I did look back a bit just to say what came in last year, because again, we had quite a lot of reforms last year. But the Employment Rights Bill, which is what the Labour government are bringing in, it's going to cover unfair dismissal. So people might have seen that in the press. At the moment, people need to have 2 years service before they have protection against ordinary unfair dismissal. It's going to become a day one right. So subject to a sort of statutory probation period, people will have protection at day one from sort of being unfairly dismissed. So that's sort of the main headline of it all. There's the third party harassment and the sort of new liability for that they're proposing to bring in. We're expecting to see more restrictions on the use of 0-hour contracts. Initially, the Labour government, the Labour Party at the time, in their manifesto said they were going to ban them outright. But of course, there are some individuals and actually 0-hour contracts actually suit quite well. But we're expecting to see some restrictions and some sort of tightening up around the use of 0-hour contracts. Fire and rehire as a practice. So you get some situations where businesses want to implement change, and they use this thing where they sort of dismiss and re-engage. So they basically say to people, here are your new terms, you either accept them or your employment will end at the end of your notice period. Again, some tightening up a lot around that as a practice, some sort of consultation and some more sort of a focus on fairness, which I think is probably going to mean that lots of businesses will use restructuring and redundancies as opposed to a dismissal and re-engagement, or a fire and rehire, as we will call it. And then just finally some tightening up around the redundancy provision. So at the moment, collective redundancy consultation is only triggered where you make 20 or more people redundant at one establishment. So for businesses that have various different sites, they don't always trigger that collective redundancy consultation to sort of appoint reps and do a bigger consultation piece. And there's a proposal to simply remove that requirement. So remove the establishment test. So it's just if your business, wherever your establishments are making 20 or more redundancies, you are going to trigger that requirement to collectively consult with your employee representatives or trade unions.
Okay, so that's quite a lot.
Time.
We might need to be hearing from you again, Lauren, because it's been really useful this morning. Thank you. You've covered an awful lot of information. As you said, we'll make the presentation available to everybody who's registered for today's webinar, and also the recording, because there was quite a lot of detail in there, and it might be that people just want to catch up on specific parts of it. We are currently looking at the further program of Workspace Wisdom webinars, and we will hopefully be sharing details of these very shortly. But so do keep an eye on our website and your email inbox. But thank you very much, Lauren and RWK Goodman, for the presentation this morning. Thank you. Goodbye.
Thanks.